Good afternoon and welcome to the first webinar of the BNI Taguig webinar series. With so many challenges, this year has certainly become quite unique. The business norm has changed or evolved, with many of us having to learn new skills, restructure, or redesign the way we operate. The objective of this webinar series is to provide practical information which are more relevant to the local market and transform local businesses towards sustainability by fostering the culture of collaborative learnings. We're extending a special welcome to those who are not familiar with BNI, and we will share a little more about this at the end of the webinar. Our webinar today, sponsored by BNI ELITE, is entitled Our Business Reimagined, Legal Guide for Business Continuity. This aims to give practical and legal guidance on common legal challenges of today. I am Pancho Joaquin of Reliable Paralegal Services and Solutions, Inc., a proud member of BNI ELITE, and I will be your host for today. We have lined up three powerful speakers, but to set the tone for today's session, please remember, there are three people with whom you must be totally honest and to whom you must listen. One is your priest, as he can save your soul. Two is your doctor, as he can help save your life. And three is your lawyer, as he can help you save everything else. So for our first speaker, to discuss legal and effective debt collection for both creditors and debtors, is attorney James Michael Chua of Lim, Chua, Dave, and Cervantes Law and Accounting Offices. Attorney Mike is a proud member of BNI Dynamic. Currently, Attorney Mike is the corporate secretary for 5 corporations in the construction, realty, cargo logistics, chemical, and insurance industries. He has been handling cases and maintains specializations in labor, aviation, corporate procedure, criminal, and intellectual property law. Ladies and gentlemen, Attorney Mike Chua.
Good afternoon, everyone. So today I will be discussing how to legally and effectively deal with collections. So some fun fact for you before we proceed. Did you know that demand is necessary for a debtor to be declared in default? So without demand, the obligation is not yet due in demand default. Likewise, interest and penalties incurs only after demand has been made. So if you don't demand, if the creditor did not give a demand, no interest or penalties shall incur. Okay. So third, no person shall be imprisoned by reason of debt alone. And lastly, in cases of service agreement, if the contractor refuses to perform his obligations, then you cannot compel him to do so. Otherwise, it will tantamount to involuntary servitude. Oops. Okay. So how to legally collect debts? I will be discussing both on the perspective of the creditor and the debtor. So let me start off with the creditor. So step 1, send a demand letter. A well-drafted demand letter should include the date, the amount due, the breakdown, a notice for settlement, the time frame within which the settlement should be paid, and lastly, the terms and conditions for the debts to be settled. If the debtor did not pay the debt, then do a follow-up. So that's the step 2, follow-up letter. Follow-up letter should include the details which was included in the previous demand letter. Okay, but this time around, the demeanor must be stronger. So if the debtor still fails to pay, then the creditor have no choice but to resort to final demand letter. This time around, the final demand letter, the details of the final demand letter is the same with the first demand letter. But this time around with an ultimatum that if in case the debtor still fails to settle his obligation within the time frame given, if, the creditor shall file a demand before a competent court of jurisdiction. If no payment has been made, despite of the three demand letters, then the creditor has no other remedy but to file a case for recovery of sum of money. Okay. So what is the remedy of the debtor? First, the debtor should answer the demand letter. The debtor should not be afraid of the demand letters because they are not lawsuits, but rather mere notices or reminder that they have an obligation to settle. The more that the debtor ignores the demand letter, the likelihood that he is going to be sued. So what is the next step? After, so after submitting a letter, he should settle the obligation. So if he has means to pay, then pay it. If he does not at the moment, but has future availability of funds, then he should settle it or ask for an extension of time. However, if the debtor has no means to pay for the whole debt due, then the only recourse that he has is to propose an alternative mode of settlement. He can go for dación en pago, foreclosure mortgage, or legal settlement. Everything else, um, he should consult a lawyer like us. Why? Because lawyers are effective in cost saving. Lawyers can propose conditions, propose provisions of settlement within which the debtor can save money. At the same time, lawyers are effective negotiators. So, what are the alternative remedies that a creditor has? First, the creditor can resort to dación en pago. What is dación en pago? The creditor can opt to exchange something of equivalent value as payment. So, if, for example, the debtor has a debt of 1,000 pesos. The creditor, sorry, yes, but he has no money, but he has a cell phone worth 1,000 pesos. The debtor can opt to exchange that cell phone to the amount owed. So, if there are securities given, the creditor can foreclose the chattel or real estate mortgage. So, for unpaid seller, uh, the cred- for unpaid seller, the creditor can opt to cancel the contract through notice and require that the goods which are unsold to be returned. And lastly, for service agreements, if the contractor does not fulfill their obligation, the creditor can opt to hire someone else to perform the obligation, and then seek for reimbursement from the debtor later on. So, how about the debtors? What are his alternative remedies? Okay, for the debtor can, if the if the debt becomes due and demandable during a fortuitous event, then the debtor cannot be made liable to pay for penalties or interest. Okay. The debtor can also resort to dación en pago, which is like previously discussed, is the exchange of something of equivalent value to the amount of debt. The debtor can also enter into alternative modes of settlement, which is to forfeit, if agreed upon, to forfeit the thing pledge or the thing mortgage. So, what are the tips? So, what are the tips that we can give as lawyers to both creditors and debtors? So, first, the creditors should protect themselves by including penalty provisions in every contract that they enter. So, the provision should be concise and detailed, as to include what penalties and interest must be imposed, and when they should apply, and on what rate. Second, they should always ask for securities. So, be it a pledge, or mortgage, whether shuttle mortgage or a real estate mortgage, they should ask for securities because if the debtor fails to pay, at least they have a backup plan. They have something to recover. So third, demand letter. Remember when previously discussed, a, a debt is not due and demandable unless there is a demand. So for the creditor to be able to collect, they should send out a demand letter. So the creditor should be wary of the prescriptive periods because if the creditor did not observe the prescriptive period, they don't want to away with their debts just because the creditors left on his right. Always have a plan B. Consider other so they can go X deals, recovery of unsold goods, foreclosure of mortgage, and lastly, when everything else fails, debts. The creditor can consider the debts as losses. Anyways, they can deduct it from the tax due to the government. So, what are the tips for debtors? What are their valid defenses? First, fortuitous events. Debtor can always raise fortuitous events, provided that the debt due shall fall during a fortuitous event. If in case that happens, then the debtor should not be liable for any penalties or interest that incurs during the delay. So one good example of that is the Biennial to Heal as One Act. So during the COVID pandemic, the government proposed a measure within which to alleviate the burden of everyone to pay, the burden to pay for each businesses, including each individuals. So during in Biennial to Heal as One Act, the debtors are given 30 days extension within which to pay their corresponding payments, which is already due. Okay. So the debtor can also raise prematurity if in case the creditor should file a case without sending a demand letter. The debtor can raise prematurity and request that the case be dismissed because the cause of action of the creditor has, is not yet present. The debtor can also raise prescription if in case the creditor um, did not file any case within the period prescribed by law. Then and such right has already elapsed, then the debtor can raise prescription that they can say that the right of the creditor to demand payment has already expired. And lastly, the debtor can propose alternative modes of settlement. So, like previously discussed, alternative modes of settlement are, for example, are dación en pago, or they can foreclose the mortgage, or they can cancel the contract and request for the return of the goods delivered if unsold. So that's it for today. Thank you for listening. I hope you understand.
Thank you, Attorney Mike, for your enlightening discussion. While I still have you, could you please explain more what is a fortuitous event or force majeure?
Okay. Fortuitous event are events which are unforeseeable or if foreseeable, inevitable. So if I could expound on that, fortuitous examples of fortuitous events are typhoon, COVID pandemic, earthquake. These are events which cannot be prevented, or those events which cannot if cannot be seen, or if foreseen cannot be prevented. Force majeure, on the other hand, are those events which are similar to fortuitous event, but this is due to months participation, for example, war, strikes, lockouts, riots,
Mm.
which prevents a debtor or a debtor from performing his obligations.
Okay, so for example, other than the virus itself, how would you classify, let's say, government pronouncements such as declaring an MECQ, GCQ, which prevents people from going to office or going to work? How would you classify that? And can that be used as a defense for debt collection?
Yeah. Actually, the government measure in preventing businesses to open during ECQs or MECQs are one good example of fortuitous event, which allows the debtor um, to escape the burden of penalties or interest that is usually imposed during delays. So one good example is that, as previously discussed, the Bayanihan Tuhil as one act, wherein all industries, micro industries to medium industries, are given leeway to settle their obligations. For example, rent or loans, they are given 30 days grace period.
Okay. So thank you, Attorney Mike. We will see you later for the Q&A. Now, our second speaker will discuss how to prevent and minimize health risks of employees, clients, and visitors, as well as data privacy compliance pertaining to health declaration forms and the app. He is Attorney Ismael L. Sarangaya Jr.
Sorry, Pancho.
of the Sarangaya Law Offices. Hello, Attorney Isma. Attorney Isma is a proud
Hi.
member of BNI Champions. He is a professor of law, a bar reviewer, and a regular speaker for the Labor Relations Summit, Risk Management Seminar,
Hello.
and Regulatory Compliance Summit hosted by IAM Training Services. Wow. He specializes in litigation, labor, intellectual property, estate settlement, property laws, corporate compliance, and data privacy consultancy. Ladies and gentlemen, we're so glad to have Attorney Isma Sarangaya.
Hello, guys. Good afternoon. Soon to be good evening. So, a blessed and energetic afternoon to everyone. First and foremost, I would like to thank BNI Elite and BNI Taguig Region for having me. It is a blessing, and I'm humbled to be invited here and to speak alongside the brightest lawyers in the Taguig region, at the very least. So, for this afternoon, no, I know you have a lot of questions about the topic because for BNI members, all of you are business owners, and even for some of our guests as well who had the interest in joining us this afternoon. How can we really safely reopen our businesses given that uh, the virus is still there? So here's the situation. Uh, the government is already excited to gradually open the economy in view of the impact of the strict lockdown measures that we adopted before. Um, for a good 3 or 4 months, there was ECQ, and then followed by MECQ, and then GCQ. We're still in GCQ. Most parts of the country are still in MGCQ, the looser form of quarantine measure. And it has taken a toll in our economy. That's why the government is so interested in gradually opening up our economy. But here is the scarier part. No? Despite the optimism, and in fact, we are seeing a decline in the number of cases, at least in Metro Manila. I just read the news, and we have about 900 plus new cases with below 200 recoveries. So it is quite a development or an improvement, but at the same time, we have to recognize this reality that the virus is still around. And as long as uh, we don't have a vaccine, or as long as the COVID-19 virus is not yet eradicated, then there is a cause for concern. If, if not uh, a legitimate need, you know, to be cautious in our actions. So, with the limited time allotted to me or given to me, let me share a few tips on how to safely navigate, how to safely reopen your businesses, and at the same time without compromising your profitability, without and of course in compliance with the relevant government issuances. So, so number one, no, you have to implement health and safety programs in the workplace. So as employers, it is your management prerogative to come up with company policies that would aid the business in maneuvering towards reopening. So you have to take into account the health and safety measures that the government is imposing. So we have the DTI and DOLE supplemental guidelines on the prevention and control of COVID-19. So this sets forth the minimum standards that each business has to observe in its attempt to reopen. No? So you might be wondering why masks, face shields, shuttle services, and these items are included. It's because it's covered by the supplemental guidelines. In fact, earlier, DOLE and DTI issued the so-called interim guidelines for the prevention and control of COVID-19. So this supplemental guidelines aim to bolster the current safety measures that the government is implementing. So, for example, as far as masks, face shields, physical distancing, and even disinfection of premises, it's very important that your company is abiding by these standards. No? So the quality of mask that you should use, the fact that a visor is not allowed to be used, because I'm still seeing people maybe out of their inclination for fashion would use a visor type face shield. That's not allowed under the supplemental guidelines. And of course, with respect to distance, you have to observe, ideally 2 meters distance with your colleagues, but the minimum is really 1 meter. And of course, for disinfection, do not forget that the first employees to arrive and the last employees to leave should be given the task of, cleaning up the premises to ensure that no trace of the virus would be there when you leave. Or as far as arrival, whenever employees come in, that disinfection is implemented or conducted for everyone to safely stay in the premises. Not just that, there should be, investment that employers should make as far as resources concerned. From soap to the sanitizers to the signages, uh, for shuttle services, it's actually required for large size or medium enterprises. Well, the supplemental guidelines define large and medium enterprises to mean at least 15 million worth of assets. No? But in the clarification embodied in advisory number 02-20, no, the DOLE and DTI elaborated that those in special economic zones, those large establishments with uh, capitalization or assets worth 100 million are required to provide shuttle services. Yes, that's right. What if your company has no budget for shuttle services? So under the clarification, employers are allowed to find ways such as cost sharing agreements, uh, partial vouchers with TNVS companies, or other alternative means to provide transportation services to our employees. Because, it's very important that the employees would be safely transported from their place of residence to their place of work. Not to mention that even up to now, depending on the applicable uh, regulation of the IATF, we must still avoid mass gatherings. So as far as your workplaces are concerned, make sure that for high-risk areas or for those enclosed areas, you maintain only a seating capacity of 10%. For high-risk areas, or for low-risk areas rather, or those areas in your workplace which are open spaces, at least 50% seating capacity. And if the meeting would last 15 minutes or more, then just make it a video conference meeting. Just use technology in conducting that meeting. You should also revisit your or in fact recalibrate your heating facilities, the ventilation of your workplace, as well as your air conditioning facilities, to make sure that as much as possible, natural air would be circulating. You're also interested about contact tracing, testing, isolation, and referral, I know, as well as reporting and notification. I cannot discuss everything given the limited time, but here is a very important question. Are all employees required to be tested? And what kind of test should be used? No? So employers are encouraged to come up with partnerships or alliances with the local government units, as well as other concerned government agencies for testing. And in fact, what is encouraged is the conduct of RT-PCR testing, or what we call swab testing. Now, there are certain employees who are required to undergo RT-PCR testing. For example, for those priority industries like employees in the tourism and hospitality sector, or those in the front lines. No? So, for example, I saw my chapter mate, an owner of a nail salon. No, it's one of those included as a frontline industry. And in fact, the DTI and DOLE supplemental guidelines encourage employers to conduct RT-PCR testing at least once every quarter. And of course, it's mandatory to conduct RT-PCR testing for those employees who are encountering or experiencing symptoms of COVID-19. Also, another trivia that you must consider is the fact that even before the conduct of test, your OSH, OSH officer, it stands for Occupational Safety Health Officer in your respective workplaces. he or she has that duty to notify the local government unit as well as the barangay health emergency team that someone in your workplace is experiencing a symptom or is a probable case or is a close contact of someone who is confirmed to have COVID-19. So you see, so the reason why I'm saying all of this is because you need to craft a good company policy moving forward. In order to facilitate the reopening of your business, you must have a plan. And your plan must be in keeping with the minimum standards imposed by the government. No? You are not prohibited from coming up with your own policies. So for example, for the closure of your buildings in case of a positive case, right now you are allowed to come up with policies for closure. And you are even allowed to have granular closures in your respective workplaces, as long as there is a sufficient policy that would ensure the regulation as to the entry into your premises and the maintenance of safety and the health of those present. Second, you need to educate everyone, not just your employees, but even your visitors, everyone who enters your establishments must be educated. And you must ask, is that mandatory, attorney? The answer is yes, because the DOLE and DTI supplemental guidelines mandate the display of signages, visual cues, and reminders, no? So that everyone would know what to do. For example, how to wash your hands, no? A reminder to wear your masks, a reminder to wear your face shield. So that's very important, among other things. And not just that, no? If you have your OSH officer in your workplace, he or she must be aware that it is his responsibility to come up with mandatory advocacy awareness raising programs, no? To make sure that everyone is aware of the developments, no? What to do in the workplace, the safety protocols, as well as the latest information provided by the DOH, by the other concerned government agencies, as well as the World Health Organization. Third, you must innovate by implementing or adopting flexible working arrangements. Even before the pandemic, we already have this law, RA 11165. Sorry, I'm talking about the law, but I hope you don't mind because you must be aware of this, the Telecommuting Act. When we say telecommuting, it simply means an arrangement wherein work can be done by an employee in an alternative place. And that is actually what we're doing right now. In fact, the relevant government issuances encourage the adoption of flexible work arrangements, of work from home arrangements. No? And also, there is this labor advisory number 17-B, series of 2020. So what's this? So this is the latest advisory pertaining to the adoption of flexible work arrangement. You know, that employers may adopt arrangements such as work from home or alternating schedules or even temporary closure of an establishment or a part thereof, as long as the employer would abide by the provisions of the applicable laws and regulations. So RA 11165 is an example. No? So what do we mean by that? For example, you are adopting a work from home arrangement. Of course, it can be avoided that there are some employees who are still working in the actual premises of your companies. But the employment benefits, no, as well as the other incentives of those working from home should not be prejudiced by the mere fact that they are not in the work premises. And they must also be provided training and resources for them to perform their functions even from remote. Also, this is fairly new. Department Order number 215, series of 2020. For example, you place your employees on floating status on account of the pandemic, particularly COVID-19. So, based on this new department order, the suspension of work relationship may be extended for another 6 months, but there are conditions. Number one, the employer and the employees, as assisted by the Department of Labor and Employment, must meet to discuss the extension of suspension of employment relationship. And the DOLE must be notified of the implementation of this measure 10 days before the actual implementation date. And employees must not be prohibited from seeking other employment. And in fact, their relationship with their true employer would not be severed unless, of course, there is a clear and unequivocal letter of resignation coming from the employee concerned. So those are the things that you must take into account. And finally, since I'm proud that my chapter is into technology. So kaway-kaway, mga champions, fintech is the key, right? So for those of you who are using PayMaya, Gcash, and similar apps, you may be doing the right thing. And if you are an employer, you may want to consider this, because the exchange of actual money can be a means to transmit the virus. So Labor Advisor number 26-20 defines a transaction account to mean a bank or e-money account held with a BSP regulated financial service provider that can be used to store, send, and receive funds. So take note, BSP regulated. So you have to visit the website of BSP to check which ones are registered and regulated by the government, particularly by the Bangko Sentral ng Pilipinas, for your own good, to make sure that your money is in safe hands. So these are the tips that can be called from the labor advisory. So number one, employers must educate the employees regarding the use of transaction accounts, why this is more beneficial instead of the traditional, handing the money type of payment of salaries, right? So just to be clear, employers are not prohibited from maintaining the traditional setup. And this is just a directive or a suggestion coming from DOLE, But at least provide your employees options. And if your employees opt to be paid their salaries and benefits by way of a transaction account, the employers must assist these employees in opening these transaction accounts. What if there are service charges, fees in the opening of these transaction accounts? That must not be charged to the employees, remember? And of course, do not forget compliance with existing laws and regulations, such as data privacy, part of which I will discuss in a bit. And don't forget that even with the use of transaction accounts, you, as employers, you must still issue pay slips or record of payment. Okay? So don't forget, aside from the 4 items that I've discussed, don't forget data privacy, especially with respect to your health declaration forms, with your contact tracing forms. It's very important because the information that would be indicated there are either personal information or sensitive personal information, the unauthorized disclosure of which would get you in trouble. All right? So these health declaration forms must be handled in accordance with the Data Privacy Act. What do I mean? So let me discuss in a bit. Number one, it's a long sentence. This is, this was, these were gathered from the actual provisions of the DOLE DTI supplemental guidelines. To summarize, item number 1, proportionality, meaning only those data or information necessary for contact tracing must be gathered by the employer. Second, transparency. Another important principle in data privacy. You must inform everyone, employees, visitors, suppliers, as to the reason why their data is being collected. Third, reasonable and appropriate security measures and safeguards must be implemented by the employer. And of course, given the sensitive nature of the information processed or collected, by way of these health declaration forms, they must be treated with utmost confidentiality. And fifth, the personal data must only be stored for a limited period of time. In fact, it must not exceed 30 days, after which the data must be disposed. So recently, the National Privacy Commission issued a press release regarding the prohibition on the repurposing of the data gathered during contact tracing. So are there HR practitioners here? Kaway. So assuming there are, or for those business owners, you cannot repurpose the data there in the health declaration form later on for HR purposes. So that's not allowed. And in fact, there are specific security measures that must be implemented by the employer to make sure that these data would not be unnecessarily exposed. So make sure that in our efforts to cooperate with the government, of course, cooperation with the government is not prohibited. It's not forbidden under the Data Privacy Act, but there are safeguards that must be observed with respect to this matter. So do you have questions now or maybe later? No, I'm sure Pancho would have a couple of questions and others as well.
That's right. That's right.
Right?
Yeah, but okay, we'll reserve the questions for later because they're quite juicy. So
Okay.
we'll call you back, Attorney Isma, later on, for the
Sure.
question and answer.
Sure.
So let's go on to our third speaker. Our third speaker, Attorney Raymond Joseph Pasqua of Pasqua and Pasqua Law Offices, is a proud member of BNI ELITE. Attorney RJ has a strong background in business law, corporate structuring, and taxation, serving also as arbitration counsel in ad hoc and institutional commercial arbitration proceedings. He has extensive experience in both individual and business owners in various areas of law. Attorney RJ will speak on transitioning from brick and mortar stores to e-commerce platforms, identifying challenges for both business owners and customers, and how to address them. Ladies and gentlemen, Attorney RJ Pasqua.
Thank you, Pancho. E-commerce is developing fast. Understatement of the year. When we come across the term e-commerce, we equate it to an internet shopping activity. Nothing wrong with that. However, the fundamentals of e-commerce are way deeper. It revolves around the basis of commercial transactions built on the foundation of electronic processing and transmission of data, texts, sounds, and images. To put it simply, e-commerce is an online business. Parties carry out transactions through electronic trading rather than face-to-face transactions through a wider range of technologies such as email, instant messaging, payment gateways, and other points as well. The use of commerce is conducted in a way of spurring and drawing on innovations in the electronic fund transfer field, supply chain management, internet marketing, online transaction processing, electronic data interchange, inventory management systems, and automated data collection systems. The Philippines was an early adopter of e commerce legislation, having passed the E Commerce Act in the year 2000, with the primary objective of providing a secure legal framework for electronic commerce. The law has since been complemented by regulations in electronic evidence, e consumer protection, digital signatures, e banking, and e payment in government, culminating in the passing of both the Data Privacy Act and the Cybercrime Prevention Act, further augmenting the obligations created under the E Commerce Act. 20 years hence, we all know that e commerce has a significant potential in the country with its high level of mobile telecoms penetration, rapid uptake of mobile banking services, and a strong encouragement of business process outsourcing as a growth sector. In our next slide, we see the typical requirements we need to start a business, whether it's a brick and mortar store, an e commerce business, or a hybrid. As with any business, we start with a concept. What do you want to do? When you have this in your branding, you can start. We build the supply chain, sourcing our products, raw materials, and packaging. Then we develop our warehousing and inventory management system. From there, we engage our logistics and payment gateway partners. And finally, we comply with the necessary government regulations and bring your business to market. Unfortunately, as with all things, challenges will always be there. In our next slide, we see the common problems that many businesses face when transitioning to a purely online business model or augmenting their present business with an online component. Earlier, we mentioned the e-commerce act. The Philippines does not have a dedicated consumer protection legislation for e-commerce. However, the law does provide some recognition for the need of consumer protection in the electronic environment. The law states that violations of the Consumer Act and other relevant or pertinent laws committed electronically are penalized as well. Now, let us go further back to 1992 when we adopted the Consumer Act of the Philippines as the legal basis for consumer protection in the country. The law embodies the state policy on the protection of consumers and establishes standards of the conduct of businesses and industries in the country. It is the Philippines' main consumer law, focusing on protection against deceptive, unfair, and unconscionable sales practices, as well as ensuring consumers have adequate access to redress. We also have various regulations from different bureaus and departments further strengthening the law. These regulations aim at protecting consumers doing online transactions, specifically the purchase of products and services from both local and foreign based sellers. Part of the guidelines include mandating minimum requirements that e commerce sites must comply with, such as your privacy policy, your product information, your consumer complaints hotline, among others. Now, from consumer satisfaction, we move to consumer protection. A common concern in online transactions is the security of personal data. Many consumers disclose sensitive information like credit card details, bank accounts, and passwords, unaware that these can be intercepted and used for illegal purposes like identity theft, credit card fraud, or sale of personal information, all of which are criminalized under the Data Privacy Act of 2012. This is one of the most modern privacy laws in the ASEAN region, incorporating a mix of guidance from the European Union, APEC, and OECD. One interesting feature of the law is the large number of criminal offenses it creates. Incidentally, most privacy legislation around the world are based on administrative or civil infringements rather than criminal offenses. In any case, the online seller may only process personal data within the scope of the transaction and all purposes related to it. Thereafter, the online seller is obliged to block or delete the personal data once the transaction is accomplished. Even consumers are expected to read the privacy policies in detail before agreeing to them. As business owners, we must monitor the data collected under our e commerce platforms, since any data breach is a cause for alarm. Many of us may see upgrading online security as a cost center that burdens growth, but having a secure system pays dividends over time. Corollary to data privacy is cybercrime, covered by our Cybercrime Prevention Act. Yes, that controversial Cybercrime Prevention Act. Cybercrime was partly dealt with under the E-commerce Act, stating that hacking, cracking, or unauthorized computer access to corrupt, alter, steal, or destroy electronic data are all offenses. Now, with all of this, compliance with the BIR is still paramount. Whether you have a traditional brick and mortar business with a storefront, an online business, or a hybrid, as your accountants may tell you, tax compliance is important. While we all saw that in these past few months there was indeed a lot of growth in the e-commerce industry in our country, the BIR has identified those e-commerce segments that need to comply with registration. These are e-commerce platforms like Lazada, internet retailers of consumer goods, digital services, memberships and subscriptions, digital transactions through the use of electronic platforms and media, online blogging, filmmakers earning from advertising through their online channels, and ride hailing services for food, transportation, delivery, or merchandise. But please note that registration is independent of tax liability. We can all be registered and not be liable for taxes. In our next slide, we have a traditional brick and mortar store selling products from its storefront before the pandemic struck. The migration is seamless, care of many of our BNI colleagues in the audience. However, this is his first time expanding as an online business, and he's unsure how to remain BIR compliant. So, how do we do it? Under Revenue Memorandum Circular number 60 2020, just update your business records with the proper RDO of the BIR. Just include that you're doing online sales. It's that simple. It's different in our next slide. We have a homemaker looking to support her kids with her cookies and baked goods. The answer is not as straightforward as the previous case. But still, as a general rule, registration with the proper government agencies is always the best practice. As you can see on your screens, we have proposed one solution involving government and trademark registration. Allow me to postulate another. Our homemaker can register as a barangay micro business enterprise under RA 9178, since these enterprises are by law exempt from tax from income arising from the operations of the enterprise. Something to think about. And finally, in our last slide, we see that the use of the internet, the electronic purchasing system, SMS, and multimedia messaging, and other electronic means of interchange have revolutionized business transaction in our everyday lives. Such trend towards modernization and technological advancement necessitates knowledge and understanding the interplay of all the laws covering your e-commerce business. As electronic commerce is expected to account for roughly 50% of our GDP in the next few years, online merchants will be expected to register with the DTI, the SEC, and the BIR, among others, to formalize their operation and to strengthen transparency and accountability to the public. Thank you and good afternoon.
Okay, thank you, Attorney RJ. That was quite interesting. RJ, before we go into the Q&A with everybody, just one thing, when one realizes that he has been hacked, cracked, or there's an unauthorized interference with his account, what's the immediate legal remedy that he can take?
Well, Pancho, my knee-jerk reaction is call any one of us, right?
Correct.
Yeah, but kidding aside, uh, report the incident to any of these three agencies. So you have the NBI's Cybercrime Division, the PNP's Anti-Cybercrime Group, or the DOJ's Office of Cybercrime. Any of these three government agencies can address your concerns immediately because we have to build a case. They're the best persons to call to investigate.
Okay, and then you make sure that you get the details of the call, who you talk to,
Yeah.
what's this position in that agency, and would you suggest that they write a letter also, so
Well,
that
they can write a
there's
letter.
a
Well, yeah, they can write a letter. They can email. Uh, well, the traditional way is just going to the office, but at this time it's impractical. So the email or a call would be the best choices.
okay. And one more question with respect to the e-commerce, no? Considering the creativity and ability of computer users, how can one properly recognize if an electronic document is authentic and is reliable?
Okay, interesting question. Well, I'll divide it. For purely electronic documents, there is the digital signature. So the Department of Information and Communications Technology, they have the certification guidelines and technical standards for these. So they can if you need to identify the digital signature of your electronic document, you go to them. So it's the DICT. Okay. For scan copies that are emailed to you or whatnot, well, we can get the certified true copy care of reliable paralegal services and solutions, right?
Yes, of course. Okay. Okay. So, okay, let's now invite our other speakers, Attorney Isma and Attorney Mike, to join us by unmuting themselves and turning on their videos for the question and answer from our attendees. Okay. So let's go to the first question. By the way, bawal ang judgmental. The one who asked the question does not necessarily have that problem. Okay. So our first question, I guess, is for you, Mike. No, the question is from Jovet Soon. Uh, And it's this: if I issued a check to pay for my debt, but it bounced, what will happen? And the follow-up question to that is, how do I avoid prosecution from a bouncing check?
Okay, nice question. Well, if the debtor issues a check as payment for the obligation and it bounce, basically the debtor shall be liable for BP 22. That's bouncing checks law. Okay, so how does he escape liability or under the law? Basically, he has to pay from the time that he receives the notice or the demand. He has to pay within 5 days from such notice. So that's it. So basically, that's how you escape that liability.
Okay. Okay. Next question is for Attorney Isma from Jeanette Alba. The question is, the employer doesn't want to open the business during pandemic, but the employees requested to work even for a lower pay. Due to pity, the employer opened the business. What protection does the employer have against labor cases?
Good question, no? So the Department of Labor and Employment issued the labor advisories to the effect that the reopening, the resumption of businesses, as well as any temporary or alternative work arrangement and adjustment of benefits and salaries for that matter must be arrived at in consultation between the employer on one hand and the employees on the other hand. So if you will remember, there is a labor advisory which says that in case of adjustment in the benefits and salaries, there must be a written agreement to that effect, which presupposes that the employees agree to such arrangement and that the agreement is only for a limited time. In fact, it should not exceed 6 months. No? But with the again with the issuance of this new labor advisory 17-B, we must also take into account the fact that any temporary arrangement must not diminish or the salaries and benefits of employees. We must conform also to the doctrine of non-diminution of benefits. You know? So it must be balanced. So to answer the question, come up with an agreement, and that agreement must be arrived at in consultation with each other. So that would protect you.
A follow-up to that, you mentioned that it's good only for 6 months. If this
Yes.
situation persists, no? Can that be extended for another 6 months?
Yes,
Because
that may
it's
be extended for another. Yes, that may be extended for another 6 months after review, and again, only if the employees agree. No?
mm,
So in case of extension, there must be consultation and agreement. So put everything in writing, no? And in fact, there's a provision in the labor code pertaining to force majeure as well. So you have to consult that provision. So everything must be in writing and always arrive at everything in consultation. So it pays also to have a labor management council in your workplace so that both the employers and the employees can share their views as to how to move forward.
great. Thank you, Attorney Isma. Okay, the next question, I guess this would be for Attorney RJ. The question is from Dr. Noreen. I buy stuff online through Lazada, etc., but I worry about my credit information. Question, are my transactions safe?
Well, they should be. Lazada.
Okay.
No, no, because uh, well, they should be. First of all, you have to understand the internet it's really by nature unsecure. So, which is why when you share your credit information, Lazada is required to take care of it. Because of the number of transactions that passes through Lazada day in and day out, they have their own data privacy officer. They have their own team to watch over all of the data they collect. and then so they collect them, they purge them as it goes on, no, as all the transactions go on day in and day out. So they are compliant in that regard. They're also compliant with the data privacy law and their registration with the National Privacy Commission. So yes, you would expect your transactions to be safe, but still, because of the very nature of an online transaction, it's since it's unsecure in general, you also take precautions. So you assume that Lazada takes care of your data, but in between it may be intercepted. So you also, so as as the customer, you have to monitor your purchases as well. So it's not only on Lazada watching its back, making sure that its infrastructure is flawless. You also have to look at your purchases. Are 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 your passwords secure? Because like there are people who leave their Facebook logged in on a shared computer. So it might be like that on your part. Take care of logging off. Take care of watching your credit purchases and double checking if you made any unauthorized purchases. So, but in general, your transactions are safe. Your transactions are, it's all okay. It's all good.
Okay, thank you, RJ. Attorney Mike, a question from you for you. Uh, this is from Anonymous. Itago na lang natin siya sa pangalang Pancho.
All right.
My landlord is demanding from me to pay the unpaid rents for March, April, May, and June 2020. Otherwise, he will file a case against me. Does he have the right to do so even if I did not have any business? So I guess it's an office space. Ba?
Yeah. Well, under the Bayanihan Act, not to heal as one act. Basically, it doesn't discuss about commercial rents, but under the DTI guidelines, the DTI issued a memorandum allowing um, for a 6 months installment of the payment of rents. So under the Bayanihan to Heal as One Act, all rents shall have a 30 days grace period extension. The DTI guideline expanded or clarified such extension and said that the the lessor or the person renting can pay the rent due for in installment for 6 months. So, but he is still liable. I mean, he's still liable to pay, regardless if he has business or not. He's still liable to pay the rent, but he can only defer the payment without penalties or interest.
Okay. Thank you. Uh, good to know. Good to know. Okay. Now for Attorney Isma, I guess these are two questions that I'll put into one. No? Okay.
Sure.
The question is, um, what if all the safety and health assurances and protocols are in place in the workspace, and an employee is still hesitant to report to the office? What can the employer do that is fair for all? The other question, similar, if an employee is still not reporting to the office, even if HR sent a letter, can we hire a new employee? So I guess you can combine that
Yes.
question. Okay.
Well, as regards the employee being hesitant, of course, the issuances of the DTI and DOLE, as well as the labor advisories, always encourage the adoption of flexible work arrangements, such as a work from home arrangement. So that is the priority. No? As long as the work can be done at home, then that arrangement should be adopted by the employers. Now, as regards the second question, what if there is a directive for coming from the HR for the employee to report for work? So that depends. My labor perspective here is it depends on the nature of the job of that particular employee. If the job can only be done in the workplace, and the first question question presupposes that all safety and security measures and health programs are implemented by the employer, then as employers, you have the management prerogative to direct the employee to uh, to go to work. Now, can you replace that employee? Not automatically, no? Because you may be accused of constructively dismissing that employee, no? So, but again, no, ultimately, disputes are not encouraged. That's why there are conciliation mechanisms. So if there are conflicts, no, you can read this in the labor advisories. You must resort to either of two things. Number one, your grievance machinery. If you are an organized establishment, meaning in the vernacular, may union kayo. Kung wala kayong union, then a conciliation proceeding is proper. This time, you have to go to the regional office of the Department of Labor and Employment.
Okay, great, great,
So
great. Thank you.
that is if the situation goes extreme.
Okay, thanks, Attorney Isma.
So I hope I was able to address the questions.
Yes. Okay. And considering the time, I guess we have one last question. Now for Attorney RJ. Um, Dalawa to eh. Pagpipilian ko. Sige, ito na lang. I'm an employee and my online business was just for the pandemic. Will that be a problem with the BIR?
Everything's a problem with the BIR. Anyway. No. But kidding aside, well, if it's just for the pandemic, because under the train law, if your income is below 250,000 a year, you're not liable for income tax. Now, what we had the pandemic 6 months. If the online business is not really regular, for example, you sell fruits every other week, you sell vegetables every other week, you cook, you make your baked goods or whatnot every other week, just like our case study earlier. If it's just for the pandemic, you have the option of reporting it in general or just letting it slide because you will not really be liable unless it's a difference unless it's so substantial and so regular na it continues after the pandemic. If you plan to bring it if it continues after the pandemic and you're earning substantial income from that, you register, you file your mixed income tax return na. It'll be
Okay.
it will be problematic if you don't. But for the pandemic, chances are your income from that will be very negligible. So registration will not be a problem. But of course, if tulungan natin ng gobyerno, let's pay your taxes. If you want to declare it lang. You won't lose anything. But it won't really be a problem with the BIR.
And you mentioned earlier of registering yourself as a micro business under the barangay,
Yeah.
with the barangay, no? Wherein you will be
micro
exempted.
business enterprise. Yep.
Yeah. Great, great. Okay. There are a lot of questions coming in, but we don't have enough time to read all of them. So at this point, I'd like to thank you, attorneys Michael, Isma, and RJ for generously sharing practical and useful advices. Now, for those whose questions we could not get to or would like to learn more from our resource speakers, we're flashing now their contact details. There. So please take a screenshot of this so you can contact them anytime. Okay, anytime. So now for our special visitors who are curious and interested in learning more about BNI. BNI is the world's largest business referral organization. We are a group of professional business owners that focuses on helping growing each other's business. through collaborations and giving referrals under the philosophy of givers gain. Now, you can learn more about it by accessing the website or simply asking the person who invited you today. So before we close, may I ask each of our speakers to give their final words of wisdom to us. Let's start with Attorney Mike.
All right. Basically, financial planning and good money management has a vital role in extending the life of your business. So don't waste time watching the empire you built crumble right in front of you. Please consult a lawyer.
Thank you, Mike. Attorney Isma.
Coming from an unknown author, safety isn't expensive. It's priceless. For the simple reason that our lives are at stake in our battle against COVID-19. So a business with a plan is a business that succeeds. So don't forget to comply with the government regulations. That's the key. Thank you very much and a pleasant afternoon or evening to everyone.
Thank you, Attorney Isma. Attorney RJ.
Well, trust all of your lawyers here. We don't follow your standard playbook. We always start with your end game. Thank you, Pancho. Thank you, everyone, and good evening.
Okay, thank you again, gentlemen. And thank you to all our attendees. We hope to see you again in our next webinar entitled Our Business Reimagined, Financial Management for Business Continuity. This will be held on November 18, also at 5 o'clock in the afternoon. The posters and registration links will follow. And we hope everyone enjoyed today's webinar. As we believe in continuous improvement, we would greatly appreciate it if you could give us feedback on today's session. After this webinar, you will be redirected to a survey, or you will receive an email with a link. Just click the link, accomplish the form, and click submit. It'll only take you about 3 minutes. So thank you very much. Now, in closing, let us continue to restart the Philippines, one business at a time. Enjoy the rest of the evening, everyone. Mabuhay.
Mabuhay. More than a greeting, it's a word that captures the essence of the Filipino. Most often, it's how we say, welcome. It's our way of inviting you to our home. Our way of inviting you to the party. Our way of inviting you to the family. Mabuhay may also mean a song of hope. We may often be hit hard by adversity.
Pati na po ang pagragasa ng baha sanhi ng storm surge.
Naipit ng iyang tatay.
But we're not easily shaken. Times may change, but the Filipino spirit will always stay the same. We always find hope in the darkest hours. We always prevail. Mabuhay in itself is life. It sets a reminder to not just survive, but to live. That the Filipino may falter, and we might fall to the ground. But despite all this, the Filipino spirit lives on. We continue to persevere, to laugh and smile, to enlighten others. And even if we have just a little to give, we continue to offer a helping hand. We continue to celebrate life. Mabuhay is to move forward. More than being hopeful, it is striving for a better tomorrow. And at BNI, we share the same drive that will shape a new future. Because more than connecting business leaders with each other, we are a brotherhood. The world is changing, and we are up for the challenge. Now, more than ever, we are changing the way the world does business. And for that we say,
Mabuhay ang mga manggagawang Pilipino.
Mabuhay ang mga nagsusumikap.
Mabuhay ang mga patuloy na lumalaban.
Mabuhay ang mga makabagong bayani.
Mabuhay ang Pilipinas.
Mabuhay tayong lahat.
Mabuhay BNI.
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 Mabuhay ang BNI.
Mabuhay BNI.